use of the veto in the Security Council known as Veto Initiative, which came to fruition when the General Assembly adopted a resolution by consensus in April of 2022. Under his leadership in 2016, Liechtenstein spearheaded the creation of the legal Syrian mechanism through the General Assembly to support the investigation and prosecution of international crimes since 2011. From 2009 to 2011, he served as president of the Assembly of States Parties to the Rome Statute of the International Criminal Court, ICC. From 2004 to 2009, he served as the chairman of the Special Working Group on the Crime of Aggression. Other previously held functions include vice president of the Open-Ended Working Group as Security Council Reform, that's 2004 to 2005, chairman of the Ad Hoc Committee on the Scope of Legal Protection under the 1994 Convention on the Safety of UN Assemblies, Third Committee, that's 2002. Previously, Ambassador Winwasser worked as counselor and deputy permanent representative of Liechtenstein to the UN and was the diplomatic officer in the Office of Foreign Affairs in Liechtenstein. Ambassador Winwasser studied literature, language, history, and philosophy at Zurich University and diplomacy at the Institut Universitaire des Hautes Études Internationales in Geneva. He's going to join us remotely at this time. Ready? Okay.
Excellencies, ladies and gentlemen, it is a great honor to join you, albeit virtually, at this timely conference focused on the crime of aggression. I visited your beautiful country last summer and would have loved to come back to Armenia, but the work we are doing in New York, precisely on the topic you are discussing, unfortunately, made this impossible. Indeed, as you are gathering in Yerevan, states parties to the Rome Statute of the International Criminal Court are preparing a very important decision which will hopefully result in a significant expansion of the court's jurisdictional reach over the crime of aggression, one of the four core crimes of the Rome Statute. We are living in an era of resurging interstate conflict. People in Armenia have a keener sense of awareness of this than many others. But indeed, we are witnessing a very worrisome trend in international relations in this respect around the globe. 80 years after the adoption of the UN Charter, which has the prohibition of the illegal use of force at its core, this trend is alarming and a fundamental threat to the international order. Upholding the prohibition on the illegal use of force is more urgent than ever. And the ICC's jurisdiction over the crime of aggression is the most effective accountability tool in this respect. The role of the International Criminal Court thus also converges with the core mission of the UN Charter and helps enforce its purposes. Ensuring accountability for aggression is essential to deter future aggression and to safeguard the sovereignty and the territorial integrity of states, small and medium-sized states in particular, who often rely on respect for the rule of law as the sole protection of their sovereignty. That is certainly the case for my country, Liechtenstein, which has abolished its armed forces over 150 years ago. The foundational idea behind criminalizing aggression remains as compelling and necessary today as it was at the time of the creation of the United Nations. That political and military leaders be deterred from the illegal use of force as an instrument of policy, and if they nevertheless choose to resort to the use of force, that they will be held accountable in a court of law. For states facing essential threats, international law must not only be a set of rules, it must offer real protection. Perceptions of selectivity undermine confidence in institutions designed to uphold the rule of law and to offer equal protection to all. Excellencies, ladies and gentlemen, in the framework of the International Criminal Court, we as state parties have taken crucial steps to penalize the crime of aggression, an effort that had been dormant for decades and that today is more urgently needed than ever. In 1998, at the Rome Conference, states parties acknowledged the centrality of the crime of aggression and included it in the Rome Statute at the same level as the other three core crimes: genocide, crimes against humanity, and war crimes. At the time, it was not possible to agree on a definition of the crime of aggression and conditions for the exercise of jurisdiction, a decision that was left for a later stage. The next step was taken in 2010 at the review conference in Kampala, which I had the honor to preside. States parties adopted a strong definition by consensus based on international customary law and found a way to safeguard the independence of the court vis-à-vis the Security Council of the United Nations. As part of the political compromise that made the consensus in Kampala possible, states also decided on a jurisdictional regime for the court which was severely restricted. In particular, it excludes nationals of non-state parties from the court's jurisdiction and thus severely limits the legal protection of states against aggression. This aspect will be subject of the review of the Kampala amendments in July this year in New York, the occasion for which we are preparing so diligently here in New York and for which we will need the support from Armenia and many other partners. In the final step on the path since Rome 2017 so far, states parties took the necessary decision to activate the court's jurisdiction over the crime of aggression with an entry into force in July 2018. Due to the jurisdictional limitations I have mentioned, the court yet has to be seized with any investigation of a crime of aggression, in spite of the fact that we have witnessed a sharp increase in the illegal use of force around the globe, most prominently and tragically the aggression against Ukraine. The current jurisdictional regime for the crime of aggression, as decided in Kampala, departs considerably from that applicable to the other core crimes. Most importantly, the court does not have jurisdiction over nationals of non-state parties, which creates a massive accountability gap. In addition, even state parties have the option of shielding themselves from the court's jurisdiction over this crime. So while we have made history in Kampala and agreed on a very strong legal basis for jurisdiction over the crime of aggression, the law yet remains to be applied in practice. Despite their limitations, the Kampala amendments are the most widely ratified and successful amendments to the Rome Statute, underscoring the strength of its law and the enduring relevance and significance of the crime of aggression within the court's legal framework. The upcoming special session in New York presents a unique opportunity to address these shortcomings and align the crime of aggression with the other core crimes under the statute. The moment also serves as a call to action for countries like Armenia to join the collective effort to close this accountability gap. Now is the time to ensure that ratifiers are afforded robust legal protection against the illegal use of force perpetrated against them. Today's discussion here in Yerevan is one of the many important steps leading up to the July review, and I am confident that it will make a meaningful contribution to our shared goals. Preparations for the July session are well underway. a cross-regional group of states, has tabled an amendment proposal as a basis for the outcome we are aiming to achieve: the harmonization of the court's jurisdiction over all 4 core crimes. This amendment is both principled and practical, and it would achieve the goal of harmonization. The discussions are ongoing, and we remain very open-minded with respect to ideas how to fine-tune and further improve the text. This moment is the one envisioned by all of us in Kampala to re-evaluate the effectiveness of the Kampala Compromise. The events of the past 7 years underscore the cost of inaction. They demand that we correct the jurisdictional gap that now undermines the mission of the International Criminal Court. Taking this step will send a powerful message that we, as state parties, are committed to an international order based on international law and to accountability without exception. Excellencies, colleagues, the international legal order is not self-enforcing. It relies on mechanisms, on principled leadership informed by legal clarity and a shared commitment to justice. By taking steps to ensure accountability for the crime of aggression, we can reaffirm our support for the rule of law, close the dangerous existing accountability gap, and send a clear message that the illegal use of force is not beyond the reach of justice. Harmonization of the court's jurisdiction in July will strengthen the standing of the International Criminal Court as the central institution in the fight against impunity and make a big contribution to safeguarding the core purpose of the Charter of the United Nations. I wish you a productive discussion and a successful outcome of your deliberations, and I thank you for your attention.
So, ladies and gentlemen, my name is Uğiğ. I'm Senior Officer for International Criminal Law at International Nuremberg Principals Academy. Most of you maybe know me, and I'm very, very thankful that you made such a big trip to come to Armenia. You found time in your busy schedules to visit us in Matenadaran to have discussions on a very important topic on crime of aggression. As Mr. Ambassador, Mr. Wenaveza has already mentioned, this is something that we need to discuss about in these crucial times, in these difficult times that we are experiencing in the world. We witness different conflicts all around the world. The crime of aggression is being continued. And today we are, during these 3 days, we are going to discuss exactly this particular crime from different perspectives and different angles. What are we going to do in our first session? We are going to understand the crime of aggression from its scratch. We are going to understand how the perspective of Armenia is on the Kampala Amendment. We know that Armenia became the member to International Criminal Court since last year, for which me and also everyone sitting here are proud of, that Armenia is member to the International Criminal Court and the community. Furthermore, we are going to discuss in this panel also the developments, the review in its core issues, what exactly is going to be reformed in July or in the upcoming events around the crime of aggression and how important it is. So this is my honor to invite my distinguished panelists to the panel, and I will just remind you that we have 10 minutes for the presentations, and I will present one by one to each panelist, after which they will come to the floor and have a discussion. Please, I'm inviting my distinguished panelists to take their seats here. Hola. So, the first panelist is a very special person to me because he's also my boss. Professor Dr. Christoph Safferling, who is the director of International Nuremberg Principles Academy. He's also professor of law at the Friedrich Alexander University Erlangen-Nuremberg. He holds a chair in criminal law, criminal procedural law, criminal law, and international criminal law and public international law. At the university, he is the director of the research unit on international criminal law. Further, he is the Whitney Harris International Law Fellow of the Robert Jackson Center in Jamestown, New York. His most researches are in the German and international contemporary legal history, international criminal law, human rights law, and the subjective elements of crime. So in this session, we are going to explore the Nuremberg, where exactly the crimes against peace has been developed, and the allegations against the Nazi perpetrators were brought. And I think it's the best moment and the best experts to know how the crime against peace has been established in Nuremberg. So Professor Safferling, the floor is yours. Thank you very much for finding time to come to Nuremberg. Yes, please.
Yeah, thank you so much. Hello and good morning, everybody. And thank you, Gurgen, for this kind introduction. It's a real pleasure and honor to be here speaking to such a distinguished audience with so many friends and colleagues present. Yeah, I came here now for 10 minutes to share a little of the Nuremberg experience with you as a sort of starting point for this important conference here in Yerevan. Yes, as indeed Jürgen has mentioned, crime of aggression in Nuremberg in 1945 was actually called Crimes Against Peace. And I would like to focus in these remaining 9 minutes on the main outcome and lessons from Nuremberg for today, 80 years after 1945. So it is important to remember, and I think it resembles also what Ambassador Ringewies had just said, that in our world today, which is, in some ways going a little crazy, this rule-based and multilateral international law is under contestation and attack, and violence, power, and nationalism are rising. And Nuremberg, and in particular this courtroom 600, where the trial took place in 45-46, it stands for the exact opposite. It stands, as Ben Ferenc so often sort of pointed out, as a symbol for the approach to do law and not war. You might know that actually the place just before outside courtroom 600 is now called the Ben Ferenc Platz. In case you haven't noticed, I put a photo of the sign out there, which I can actually see from the window of my office, which always reminds me of our good friend Benjamin Ferenc. The mastermind behind the trial was Robert H. Jackson, the American chief prosecutors. And he very much sort of focused on the approach that whatever we do, when we do a criminal trial, we really have to focus on the rule of law. And he pointed out in his opening address on the 21st of November 1945, the wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. I think we cannot often enough remind ourselves of that very sentence, because it reminds us of what is actually at stake, which is the very survival of the civilization. And in his report after the conclusion of the trial to President Truman, he stated that this trial had put international law squarely on the side of peace against aggressive war. So that was very much the idea that Robert H. Jackson had when he organized this trial, that aggressive war was actually the evil as such, and that had to be fought, and aggression had to be criminalized. Now, the International Criminal Tribunal in military tribunal in Nuremberg was also a real international enterprise. We must not forget, even if I sort of focus on the US-American Chief Prosecutor Robert H. Jackson, France, the United Kingdom, and the Soviet Union were also very much involved in developing and then in actually conducting this trial. And we shouldn't forget that the chief prosecutor of the Soviet Union, for example, in his opening address said sentences like, "The defense knew that cynical mockery of the laws and customs of war constituted the gravest of crimes. They knew it, but they hoped that total war, by securing victory, would also secure their impunity." For those of you who are now reminded of current situations in Ukraine and Russia, they might remind themselves of this outspoken word of the then chief prosecutor of the Soviet Union. But it was difficult to bring four nations together with their different cultures of criminal law and criminal procedure, but they managed. They managed to actually prosecute and accuse 24 people, defendants at Nuremberg, from a variety of professions. They were politicians, they were military, with a military background, propagandists, and also industrialists, at least. They were attempted in order to show that the entire German society, the entire German nation was actually involved in the crimes against humanity, war crimes, and also in staging a war of aggression. And what they found in Nuremberg were these three crimes which I just mentioned in the agreement that was then the London Charter of 8th of August 1945. In Article 6 you had these three crimes. Number one, crimes against peace, which meant planning, perpetrating, initiating, or waging an aggressive war. Then war crimes, and finally crimes against humanity. The concept actually, again, maybe surprisingly, of crimes against peace was actually also very much I would like to show you the next picture. There we are, was very much influenced by a Soviet law professor called Aaron Chainin. In 1937, he wrote a book, The Defense of Peace and Criminal Law, and he was criticizing the League of Nations very heavily for failing to make aggression a criminal offense and create a court that would prosecute a war of aggression. Of course, also the Bion-Kellogg Pact of 1928, or Paris Pact of 1928, also was the sort of normative basis of the crime against peace. But Chainin's writings were very influential, and Robert H. Jackson had them translated into English in order to appreciate the importance of the writings of his Russian colleague. I'm not now going into the other crimes that much. We had crimes against humanity also as a new concept, obviously, focusing on a systematic and widespread sort of attack on civilization. The genocide, as a matter of fact, which is so important nowadays, was not part of the Nuremberg laws because it was too new a concept developed by Raphael Lemkin. I'm sure you're aware of that, who wrote Axis Rule in Occupied Europe in 1944, where he actually coined the word genocide, which wasn't existent before his writing. The procedure at Nuremberg was very much sort of under the anxiety that we might fail actually to achieve at a conviction, taking into account that when you go ahead with a criminal trial, you need actually to prove guilt beyond reasonable doubt. And Robert H. Jackson stated that, or made that clear in his speech on the 13th of April 1945 before the American Society of International Law, when he said that this is one of the risks that are taken whenever trials are commenced. The ultimate principle is that you must put no man on trial under the forms of judicial proceedings if you are not willing to see him freed, if not proven guilty. Luckily, Germans tend to document everything, so there were enough sort of proof in writing of the crimes, of the planning of the aggression and the Holocaust and the war crimes that took place, that were committed by SS the Wehrmacht and other armed groups, so that in the end of the 21 defendants that ended up being in the dock in Nuremberg, 3 were acquitted, but the others were convicted. 12 of them were convicted with the highest sentence available at that time, which was death sentence, and the others received had to serve time in prison. It might be interesting to note that of these 21 defendants that were actually then present in the dock, 12 were convicted for crimes against peace, and most of them who were convicted for crimes against peace were sentenced to death with this ultimate sentence that was available at that time. So what is now the lesson that we learned from Nuremberg? I said at the outset, this was the very beginning of international criminal law. That was where the crime of aggression, the crime against peace, was for the first time formulated and then indeed also executed. And the importance of this cannot be underestimated, and wasn't underestimated at that time. When we look, for example, at the behavior of the General Assembly of the United Nations and at the General Secretary, the Secretary General, in the first session of the United Nations General Assembly, the first Secretary General said, "In the interest of peace and in order to protect mankind against future wars, it will be of decisive significance to have the principles which were implied in the Nuremberg trials and according to which the German war criminals were sentenced made a permanent part of the body of international law as quickly as possible." And that indeed happened then in Declaration 95, which was adopted by the General Assembly on the 11th of December 1946, which is called the Nuremberg Principles Declaration, where these principles were then actually adopted or confirmed as principles of international law. And the first principle being there's no impunity for international crimes, and principle number 6 saying that the crime of aggression is an international crime. If certain acts of violation in treaties are crimes, they are crimes whether the United States does them or whether Germany does them, and we are not prepared to lay down a rule of criminal conduct against others which we would not be willing to have invoked against us. Again, Robert H. Jackson stating at the London conference in preparing for the INT statute, also something that we cannot sort of reiterate often enough when we look at several states that were involved at that time. But then again, it is important to remember that from the legacy of Nuremberg, also again a Jackson quote, we must never forget that the record on which we judge the defendants is the record on which history will judge us tomorrow. To pass the defendants a poison chalice is to put it to our own lips as well. So this is the outcome, and this is the lesson that we learn from Nuremberg. There is no impunity for international crimes, but we must do this endeavor and proceed with the prosecution with such sort of moral implications that we do not forget that even the worst accused have a right to a fair trial. Ladies and gentlemen, for the time being, so thank you so much for your attention.
So thank you very much, Professor, for sticking also to time and also making the introduction to the Nuremberg legacy. Now we're moving to the next panelist, Dr. Hayq. He's a scholar and educator in international law with a PhD from Yerevan State University. He has extensive teaching experience and authored an LLM program. As an Armenian representative on international legal matters for the past 6 years, he has appeared before the International Court of Justice, European Court of Human Rights, and in international tribunals. He is the co-founder and managing partner of Equality Law Partners. Dr. Hayq is a member of the ICCIB panel of arbitration and conciliators, licensed attorney in Armenia since 2016. And also from my side, I need to thank Dr. Hayq for his all work that he has done before the International Court of Justice and all other tribunals for the Armenian interest. Thank you very much. Please.
thank you very much, Dr. Petrosyan. Thank you again for nice words for the presentation. Thank you for the panelists for the nice presentation. I think the topic that we have selected today for the discussion is very important topic. Maybe it makes the life of the International Criminal Court even harder, because even without the crime of aggression, or even without the jurisdiction of the crime of aggression, unfortunately the fate of the International Criminal Court and also the effectiveness of international criminal justice in general today is sort of a bit endangered, or in a pause mode, I would say, which I'm saying with a very disturbed heart, because I think the developments that led to the establishment of the only permanent institution for international criminal justice came at a great cost for the humanity, because it cost 2 world wars, enormous sufferings, millions of victims, and many attempts to hold accountable perpetrators through adjudication, but eventually establishment of the ICC was a milestone development. I really hope that the future will be more brighter. I'll present some insights from the Armenian perspective, and also trying to cover the Armenia's approach towards the Kampala Amendment and during the ratification process and the decision made when Armenia was ratifying the ICC statute. You know that Armenia has signed the ICC statute in its initial form when there has been no amendments back in 1999, October 1st. And after that, the ratification of the ICC statute was opposed because Armenian Constitutional Court declared the statute unconstitutional. The 2 common grounds have been used in many cases of the European countries. One was the complementarity principle, very famous, and the other one was the right to receive pardons, which was prescribed under the Constitution. It was a decision of the court back in 2004. We had amended the Constitution since then twice, and when we started the discussions about the ratification of the statute recently, after the 2020 war, and especially after the aggression against the Armenian sovereign territory in 2021, starting from 2021 May, as it was indicated by an honorable speaker, keynote address. And we have been contemplating about the possibilities of invoking the ICC jurisdiction. What will it be? How it will be useful for the Armenia's case scenario? How will it be used to protect Armenia's interests and secure and safeguard Armenia? Because I consider myself that ratification of the ICC statute, maybe many lawyers wouldn't agree with me, but I'm very confident in that terms that it's a security layer. It's surely a security layer, and I'm sure that it has been played as such in the past years after ratification and entry into force. I'm very positive about that. And of course, the core crimes, we know the core crimes against humanity, genocide, and war crimes, which are a special category of crimes. But, and of course, that there's no doubt about that, but how the jurisdiction will be exercising those crimes. But with regard to the crime of aggression, we have a very special case in the case of crime of aggression. It was not, I think it is not surprising while the activation of the jurisdiction of the court over the crime of aggression was delayed a little bit. And it was not very unsurprising that we had also later on the Kampala amendments coming in 2010. And we did a late activation in 2017. And also, it's not surprising that we have so many hurdles, so many preconditions for exercising jurisdiction over crime of aggression ingrained in the Kampala Amendment itself, and which make actually the exercise of the jurisdiction by the ICC even harder. And I'm sure that all of you know that there have been, since the Kampala Amendment and since the activation of the jurisdiction of the court on that, and there has been many discussions about the jurisdiction of the court in this regard, what is required for the court to proceed with the jurisdiction. And you have, of course, the Security Council determination requirements, which is a precondition for the prosecutor to proceed. If not, you have the pretrial chamber to make a determination of this decision for that. That's kind of precondition for kicking off the investigation. But not only that, but you have also the problem with the actual exercise of jurisdiction, because Kampala allows an opt-out clause. It allows to the member states, the state parties, to opt out from jurisdiction of the aggression, crime of aggression, which kind of makes it very problematic for states joining the courts to understand whether they'll be protected from the aggressors of the non-state party. Because in the case of Armenia, the source of aggression, of course, is Azerbaijan. We know, and we understand that Azerbaijan is not a party, has never been recognized as jurisdiction, probably will never become a party to the ICC statute. I would be very happy personally if Azerbaijan made that decision, honestly. I would be really happy, would be applauding in the first row if that decision ever were made. But I'm not that positive about that. And in this case scenario, we understood with this debate that is happening between the member states, we understand that the Kampala wouldn't be granting this or no promised protection for Armenia. And we also had this understanding and perception that since Armenia has started this route for ratification of the Rome Statute in its purest form, we didn't want it to complicate this procedure even more, because adding up Kampala amendments to the ratification of the statute would make it more complicated internally to communicate this and to also to legally structure our reasoning for what is happening. Why are we ratifying this amendment only? Because there are other amendments apart from Kampala, But you know that there is also the debate about the interpretation about the Kampala amendments. If I'm not mistaken, there are groups of states which interpret the Kampala amendments differently. There's a very small group of states which interpret it more narrowly or restrictively, trying to narrow it down even to the extent that both states, the victim state and the aggressor states, need to be the parties so that the court may have the power to exercise jurisdiction, as opposed to a more general, or a common approach, which is more widespread approach among the member states, which is at least one of the parties, either member state, either victim state or aggressor state, needs to be a party, so that it enables the exercise of the jurisdiction over the crime of aggression. But still, this debate persists, and I think it persists also on a legal level, because this narrow interpretation proponents, they are kind of relying on the very restrictive approach of the Vienna Convention and also the amendment clause of the Rome Statute of 121, I think paragraph 5, if I'm mistaken, and this, which specifically makes reference to the amendments from Article 5, 6, and 7, and making it very clear that this is, and also there is a sentence in that clause which specifically talks about excess of jurisdiction in the cases when the amendment is not ratified, not allowed, of course. So this creates a lot of legal tension, a lot of legal problematic, and a lot of really uncertainties for the countries, newly countries joining the ICC, and also thinking about ratifying Kampala amendments. Actually, I had the opportunity to participate in the first, after ratification entry into force for Armenia, in a side event during the Assembly of States Parties in The Hague last year, where I had the opportunity to also partake in a side event organized by, I think, the ambassador of Luxembourg, if I'm mistaken, and about the and other member states too, about the Kampala amendments exactly, and also the review conference that is upcoming in July in New York. And we expressed also our readiness as a country, because I think for Armenia, having a very workable jurisdictional mechanism of aggression, crime of aggression, is fundamental. And I think it's crucial, and I think Armenia should be very active in this sense in the review conference in July, so that we can also be part of this process, be part of this reviewing process of the Kampala, and trying to somehow cure the deficiencies of the drafting of the Kampala. Although you have one has to be very careful not to harm more, because there are many legal intricacies and nuances that we need to be mindful of. But I'm very positive that we need to be active in this sense. This is just in 2 words from Armenian perspective. I see that my time is up. I'll maybe stop here better, and I'll be glad to answer any questions that you may have. Thank you very much for your attention.
Thank you very much, Dr. Kitakosyan. Just a small reminder to everyone, you see volunteers in the room. If you have any questions, you are we will be very happy to collect all these questions. The volunteers will hand out some papers and pens to you, so just write your question on the paper, and they will give it to me, so I can read the questions to our distinguished panelists. Now moving to the next distinguished panelist, Professor Jennifer Trahan. Professor Jennifer Trahan is a professor at the New York University Center for Global Affairs, where she directs the concentration in international law and human rights. She also serves as a convener of the Global Institute for the Prevention of Aggression. She is a leading expert on international law, international justice, international criminal tribunals, and especially the crime of aggression. She holds various positions with the American branch of IAL, including vice president. She served on the Council of Advisors on the application of the Rome Statute to cyber warfare as a part of working group advising Ukraine and others on establishing a special tribunal on the crime of aggression. She has published a lot on the crime of aggression. I'm very happy and honored that Professor Trahan, who very, very enthusiastically pushes for the changes in the Kampala Amendment, that she is here, and thank you very much, Professor. The floor is yours.
It's a great pleasure to be here. So in my remarks, I'm going to focus on 8 bis of the Rome Statute. This is the contemporaneous current definition of the crime. In Nuremberg, there was a definition in the London Charter, but it was rather minimal and circular. Maybe in the context of World War II, they felt they didn't need a more expansive definition. Maybe it seemed obvious, but for current purposes, we have sought to have a more specific definition. So as Ambassador Beneviser opened, you will know that in 1998, the crime was already put into the Rome Statute. The court was already given jurisdiction, but then the definition and conditions for the exercise of jurisdiction had to be done through a later process. And first we had meetings in Princeton, New Jersey, largely in Princeton, of the Special Working Group on the Crime of Aggression. And this resulted in the Kampala Crime of Aggression amendments, where the crime and the conditions were finalized, and these were adopted by consensus of all Rome Statute state parties in 2010. The next speaker, Dr. Carrie McDougall, will speak about the jurisdiction and trying to strengthen the jurisdictional regime. I will explain the definition, which we are not trying to amend. So the definition is not being reopened. To just briefly say, we don't only have the crime of aggression at the international level. It does exist in a number of countries' domestic criminal codes. So either the Nuremberg formulation, and Armenia is one of these. It's in Article 384 of the Armenian Criminal Code, is the old Nuremberg formulation. Rome Statute state parties are gradually putting the 8 bis formulation into the domestic criminal codes. All told, we have about 60 countries around the globe that have the crime in the domestic law. But it can be difficult to utilize the crime in domestic law because of the application potentially of certain immunities. Happy to go into these if there are questions on them. I'm going to click to the definition in Article 8 bis. The first paragraph is defining the crime, and here we go through the individual conduct. The next paragraph will be state action. And I don't think the crime is that different in requiring individual conduct in the context of certain state action. The other Rome Statute crimes also have contextual elements that largely suggest, I mean, not always that there will be state action, but they have contextual requirements as well. So if you start with 8 bis, it states for the purposes of this statute. So it's not for general use ad bellum law. Crime of aggression means the planning, preparation, initiation, or execution. So these words are taken from the Nuremberg Charter. Their last word was waging, so slight difference there. These are quite broad. You think of the execution of the crime, all the military units, that sounds very broad. But it's modified by the next clause, and by the way, the A, B, C, D are my inserting these. They're not in the Rome Statute, but I think it helps. By a person in a position effectively to exercise control over or to direct the political or military action of a state. So this is called the leadership clause. So the crime only applies to a leader, a political or military leader. Probably not picking up a mid-level commander, could, but they have to meet this clause. It's not going to pick up lower-level individuals. Now, if you go back to the Armenian version, it would. It is the broader version. It is the Nuremberg version. So it is and they're involved in an act of aggression, and I'll get to that in a moment, which by its character, gravity, and scale constitutes a manifest violation of the Charter. Well, the Charter already prohibits aggressive war. It's Article 2.4, but the crime requires there be a kind of a super clear, manifest, a very clear violation. Gravity and scale say nothing de minimis, nothing small in size, and character, it's there. If you read the negotiating history, it's clear. The word character means a clear violation. And this is different from Nuremberg, which criminalized a war of aggression. The crime of aggression criminalizes an act of aggression, which is less than a war, but then the threshold goes up a bit because it has to also be a manifest violation. And why we have this character is because use ad bellum, the rule itself is fairly clear, but there are gray areas around the rule. There's sometimes what is or is not self-defense. There are debated areas of the use ad bellum law. So what we're seeing here is they do not make a good crime for prosecution. It has to be a super clear situation. Going to the next paragraph. Whoops. Oh, yes. Act of aggression. This is our state conduct element. For the purposes of paragraph 1, again, not all of use ad bellum law, act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the UN. So that first sentence basically tracks 2.4 of the UN Charter. So crime of aggression is picking up UN Charter violations, except they have to be also manifest. And then it goes on, any of the following acts, regardless of a declaration of war, shall, in accordance with UNGA Resolution 3314, qualify as an act of aggression. And then we go on to have a list. And these are from 1974. So in the negotiations, these were not redone. They picked up existing texts. Invasion or attack, ... and including, so I won't read all of the details, bombardment, blockade, attack, and it's similar to Part A, the use of armed forces of one state in the territory of the other state in contravention of the agreement. So sometimes the state can ask for or to receive armed assistance, but in violation of such an agreement. Or the action of its state in allowing its territory to be used in marshalling an attack. So think of Belarus and allowing its territory to be used to launch forces towards Kyiv. And the last one, G, the sending by or on behalf of the state of armed bands, groups, irregulars, etc. In the negotiations, we did have debate, is this a closed list or is it open-ended? But it says any of the following qualify. So it suggests these qualify, but doesn't exclude something else. So it's somewhat open-ended, but it's closed by the requirements of paragraph 1 that it still has to be a manifest, a very clear charter violation. For Armenian purposes, I read too quickly over A includes occupation. So I just wanted to point that out because that might be, or annexation is also picked up in A. So two things you might wonder about in the list, because we used a definition from 1974, it is somewhat limited in that it was the 1974 vision of what aggression looks like. Well, what about new technologies, such as cyber? Well, you will note the Rome Statute never lists kind of its weapons systems. We call it weapons neutral, weapons agnostic. And I think this is true of all of the crimes. So cyber attacks would be in the crime of aggression. They're simply a modality. And I think this is true of war crimes, genocide crimes against humanity. You could have cyber-enabled crimes or even cyber constituting the whole crime. I was privileged to be part of the Council of Advisors on the application of the Rome Statute to cyber warfare. You can find the whole report online, working with the government of Liechtenstein, and we discussed how each of the crimes inherently has cyber within it. And I was very pleased the ICC prosecutor has endorsed this position, and the ICC is now coming out with an OTP policy paper, cyber-enabled crimes under the Rome Statute. So cyber is in the definition. Another thing you might wonder about would be non-state actors. So they were not expressly picked up in any of it. There are several references, an act of a state. So it sounds like they're not picked up, but they could be. So for attribution theory, we go to the Arsiwa, Articles of Responsibility of States for Internationally Wrongful Acts, Articles 8 and 11, you see that conduct of a non-state actor in certain circumstances like endorsement, etc., can be the act of a state. So non-state actors could be picked up there. And also in our last entry, Article G, the sending of armed bands. These could be non-state actors if they are sent by the behest of a state. So there's some inclusion of non-state actors. So just to summarize the elements of the crime, we need an act of aggression by a state. The act is a manifest violation of the Charter of the UN. The perpetrator planned, prepared, initiated, or executed the crime, or had some involvement. You actually read those words in conjunction with Articles 25 and 28 of the Rome Statute, individual and command responsibility. The perpetrator is a person in a position effectively to exercise control over or to direct the political or military action of a state, so our leadership clause, and mens rea. So I didn't talk about mens rea in the definition. It's not in the definition, so you go to the general elements in the Rome Statute. So Rome Statute Article 30 sets forth intent and knowledge, so we would also require intent and knowledge at the ICC. So to conclude, why the crime matters. So the UN Charter prohibits aggression, but we look at the world since 1945 and we've seen the world awash in aggression. Why? Well, one thing is the veto power of the permanent members. So we know if your permanent member is your aggressor, there's really nothing going to be happening at the Security Council. We've seen that with Russia's invasion of Ukraine. It also means if your aggressor is a friend of a permanent member, we're not going to see action. So the political cards have to align for the Security Council to do anything. So you could have even blatant aggression, and the Security Council is basically paralyzed. But we've had this vision that we need enforcement not only at the level of state responsibility, but individuals. We've had this vision of a more peaceful world for a long time. It really starts in the 1800s, the law, not war movement. It's the same vision they had in 1913 with the founding of the Peace Palace. Let states arbitrate and litigate instead of going to war. It's the vision behind the Kellogg-Briand Pact, and it is the vision they had in the UN Charter. And to remind, the preamble of the Charter starts, "We, the people of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind." So it is the start of the United Nations Charter. And when they put in the prohibition against aggressive force, it's not just in Article 2.4. Article 2.4 is one of the principles of the United Nations. So it is really central, but not always able to be utilized. We've heard from Dr. Safferling about the prosecutions at Nuremberg, and it was, again, the idea it's not enough to say Germany committed the acts, but we need to pierce and go beyond to individual criminal responsibility. It is the same vision they had when they concluded the Rome Statute in 1998, when they adopted the Kampala Amendments in 2010, and when they activated the jurisdiction over the crime in 2017, effective in 2018. But we do have a ways to go, as you'll hear from the next speaker, on improving the jurisdiction. The crime is extraordinarily important. If we are ever to have a more peaceful world, we need enforcement of this crime through the regime of individual criminal responsibility. All Rome Statute state parties stand behind the crime because they adopted it by consensus. But 48 in particular, have ratified the Kampala Crime of Aggression Amendments, showing they particularly stand behind the rule of law. I hope that Armenia can be state 49 in doing so, because we also could use Armenia's help in fixing the jurisdictional regime. Thank you.